Firstly, welcome to everybody for coming along today and listening to what we, or more precisely my colleague Tim, has to say. My name is Chris Goldie, and I'm one of the directors of Gifted Philanthropy, and we're delighted to be able to put this webinar on for you. As you all know, we work across a variety of the not-for-profit sector, and often we're asked by clients questions around governance, roles of trustees, questions that involve legals rather than our fundraising expertise and knowledge. So we thought that rather than try and answer them ourselves, we would invite a genuine expert to come and join us and talk to you today. So if I may, I'd like to introduce Tim Rutherford. Tim is a partner at Stone King, where he works in the charity and social enterprise team, and is very much acknowledged to be one of the country's leading experts on governance across the charitable sector. Tim, I'm going to get up on the screen your presentation so that everybody can see it, and then I'm going to hand over to you. If I could ask two things: one, to make sure you're all on mute, and secondly, if you have questions, we will have time at the end. Please put them in the Q&A box, and I will then read them out when we have a question section at the end. We aim to finish at 3 o'clock. The questions that are posed are ones that we are quite regularly asked by clients, and so we felt this would be a good starting point for Tim to talk to. But if you have any others, please feel free at the end to put them in the box, and we can proceed from there. We will aim to finish at 3 o'clock. So, hopefully you can all see that. Tim, I will kick us off with the first question. So, laws change so quickly. We're worried that we'll be missing a change in the law or the need for a policy by accident. And then we'll get into trouble with the Charity Commission, leading us to damaging the charity's reputation or getting fined. What do we do?
Okay, well, good afternoon, everyone. So, yes, the law does change very quickly, and it can easily catch all of us, lawyers included, by surprise. And to put that in context, we first of all need to just think again about how laws are made. So in this country, our laws created in two ways: the common law, so decisions made in the courts, which both interpret and apply legislation, but also establish precedents to follow, and also statutory law that's set out in Acts of Parliament and subsidiary legislation in the form of statutory instruments. Now, Acts of Parliament can take a very long time to become law and are generally quite well publicised, particularly if they're going to have a wide-reaching effect. So, for example, during the pandemic, we saw the Corporate Insolvency and Governance Act 2020 that made lots of important governance changes to cope with pandemic issues, but that took from March until June 2020 to be made, despite the urgency, but was then quite well publicised in lots of different areas. However, statutory instruments can be made a lot quicker, and that's often how regulations come into effect that can have a significant impact. And for example, we've recently had the situation of all wondering when bits of the Charities Act 2022 were going to come into force, and then all of a sudden on a Friday we get a statutory instrument telling us that a few days later bits of the Act are coming into force. In addition, case law can be developed very quickly and sometimes will actually set a leading precedent without anybody knowing, because it's only once the judgment's been made that people start to think about it. Now, on top of that, the Charity Commission and other regulators issue regular guidance, which often may be an interpretation of the law, or in some cases may actually be statutory guidance that you're required to follow. So, for example, the Charity Commission guidance on public benefit is something there's a statutory obligation on charities to follow. Now, in reality, because of all of these different types of laws and the way they're coming thick and fast, hardly anyone can really say that they know all of the law that may apply. Even lawyers today now work in very specialised, narrow fields. For example, my expertise is charity law. And as you'll see when we get to one of the later questions, I do know a little bit about some other areas like data protection, but not necessarily as much as a specialist in that field. And even those who work in the civil service or government really don't know everything. And you may have seen, for example, last week, the reports in the papers that the civil service had found a further 1,400 pieces of legislation that they knew nothing about, which all had EU laws that need to be dealt with as a consequence of leading Brexit. So the reality is that nobody can be on top of everything at any one point in time. Now, there used, though, to be a perception that charities could perhaps ignore quite a lot of the law because what you're doing is for the good and for the public benefit. And it was quite rare that charities hit the headlines for getting things wrong. But that's really changed quite a lot in recent years. And one of the obvious areas has been around data protection, where we started to see the ICO issue quite significant fines for charities. And that actually came as quite a surprise to a lot of charities to suddenly think, oh, we actually have to apply with this law. But charities are like any other organisations and subject to law in exactly the same way. So if we can move on to the next slide, the reality is that everyone, and in particular trustees, should be aware of the Charity Commission's guidance CC3, the essential trustee, which is like their sort of Bible for trustees. And that makes it clear that trustees have a duty to comply with charity law requirements and other laws that apply to the charity. But it does go on and put that into context and says the Commission doesn't expect every trustee to be a legal expert. You and your co-trustees should take reasonable steps to find out about legal and regulatory requirements and keep up to date. For example, by getting mailings from the Commission and other sources, reading relevant guidance and attending appropriate training. And the charity should also have systems and procedures to ensure that it complies with legal requirements. So I think really one of the starting points is actually to look back and say, what do you do as a charity? Do you employ staff? Do you own premises? Do you have vehicles? Do you provide any financial or regulated advice? Do you provide housing accommodation as a landlord? Do you provide medical or care services? Do you work with children or adults at risk? Do you do things like fundraising? Do you want to get tax reliefs? And by looking at all of those core activities, you can start to build up a picture of the areas where you might be covered by the more routine legal changes. And then it's much easier to work out where you can go to get updates. Now, just pausing and quoting from Charles Dickens, you'll remember in Oliver Twist, Mr. Bumble, who is described as the unhappy spouse of a domineering wife, is told in court that the law supposes that your wife acts under your direction, to which he replies, if the law supposes that, the law is a ass, an idiot. Now, it's true that some law can be quite peculiar about what it does, but in most cases, it's about fairness and treating people fairly, and quite often doing things that are common sense. And so in most cases, provided you're doing things reasonably, rationally, fairly, then in most cases, you're probably going to be on the right side of the law, even if you don't necessarily know the law. When it comes to the whole question about policies, now policies are an area where actually they're really more about what is fair and common sense. They've got very little to do with law. If you think of a conflict of interest policy, it could run to 4 or 5 pages, but most of it will be practical points, not legal points. So in most cases, the failure to have a policy isn't necessarily going to be the end of the world, as long as you're acting with common sense and being fair. And in some cases, it can actually be far worse to have a policy and then not follow it. So it's really all about making sure you're acting sensibly and with common sense. Now, the Commission does go on and make the point that obviously its role is about upholding trust and confidence. And they say, we expect trustees to take their responsibilities seriously. Then they say, the Commission recognises that most trustees are volunteers who sometimes make honest mistakes. Trustees are not expected to be perfect. They're expected to do the best to comply with their duties. Charity law generally protects trustees and therefore charities who've acted honestly and reasonably. And that was looked at last year in the High Court case all about the fallout from the collapse of Kids Company, where again, the judge quoted some old case law and quoted a previous judge who had said it would be wrong to require unrealistically high standards of legal skill, financial analysis, or detailed factual knowledge from trustees. The court should, in principle, not be anxious to find fault with charitable trustees who, while doing their best, make honest, even stupid mistakes. So I think that the answer to the question is no, you can't be on top of everything. You can't know all the law that's out there. You need to do your best and think about what areas you might need to be kept updated on. But provided you're acting sensibly and honestly, if something does go wrong, you're likely to be able to persuade the Charity Commission that it's a fairly innocent and honest mistake. Now, of course, that doesn't mean you can just use that as a defense to everything, but I wouldn't be hugely worried about missing a particular policy. But the minute you know you should have it, you should have it.
Thank you, Tim. Now, if we move on to the next question, this is one we're often asked. My trustees always look to me to ensure they're operating compliantly. How do I make them understand that ultimately governance is the responsibility of the trustees, who have the fiduciary responsibility and not that of the fundraising team?
Now, this is always quite a difficult area to get right, and it's really about trustees understanding the balance between governance and the role of the trustee and day-to-day management being the role of the staff. And when we do trustee training, we quite often produce a Venn diagram with two circles, and we try and show that the overlap between those two circles should be relatively small. You've got trustees over here making decisions, staff over here implementing those decisions, and a small amount of overlap in the middle. Now, this all depends, though, upon trustees understanding their duties and all having read, for example, CC3, the Essential Trustee, and perhaps that being given to them as part of their induction. Because then they'll remember that their core duties are ensuring the charity is carrying out its purposes for the public benefit, complying with the charity's governing document and the law, acting in the charity's best interests, managing the charity's resources responsibly, acting with reasonable care and skill, and ensuring that the charity is accountable. Now, one of the things you may have seen in the last few days is that the Charity Commission is currently working on a portal for trustees where each trustee is going to have an individual account with the Charity Commission. And the Commission are going to use that as a better way of engaging with trustees and hopefully reminding them of their obligations and continuing to share with them guidance and information so they understand their position. And this all comes back to the point that trustees need to have a clear understanding of what they're able to delegate and what they can't delegate. Now, that's always going to depend slightly on whether you're a charitable trust or a company or a CIO, but essentially, trustees can delegate implementation of their decisions, but they can't delegate responsibility. And if your trustees don't understand that, then all you can really do is try and tactfully remind them that ultimately they're responsible for making the decision. And perhaps that's a case of reminding them to read CC3, or perhaps drawing their attention to appropriate training on offer, or maybe running the occasional governance session internally, or at the very least, circulating the Charity Commission case reports that always have a lessons to learn section at the end. Now, again, this is something that was looked at last year in Kids Company, as there was a suggestion there that the CEO had effectively taken all of the responsibility to the exclusion of the board. And whilst that was looked at in the context of a company and company law duties, the comments are really relevant to trustees of a charitable trust as well as a charitable company. And the judge made it clear that there was no dispute that it was open to trustees to delegate functions, but he said that this was subject to an irreducible obligation to exercise supervision, and that trustees both collectively and individually have a continuing duty to acquire and maintain a sufficient knowledge and understanding of the charity's business to enable them to properly discharge their duties as trustees. And that whilst directors could delegate particular functions to those below them in the management chain and trust the competence and integrity of the people to whom they were delegating, that exercise of delegation doesn't absolve them from a duty of supervision to make sure the delegated functions are carried out. Now, there's no universal rule, and it really depends in each case what it is that's been delegated and the whole circumstances. But again, in that case, the judge referred back to some case law from the start of the 20th century, where it was quoted as saying, notwithstanding that the person to whom the function has been delegated may appear both trustworthy and capable of discharging the function, trustees remain responsible for the delegated function or functions and will retain a duty of supervision and control. Now, from the point of view of non-trustees, it's just as important to get it right as it is for trustees, because you don't want to overstep the boundaries of what's actually been delegated to you. Otherwise, you could find yourself in the position like the CEO in Kids Company, where you're being held out and thought of as a de facto director or a shadow trustee. So again, in terms of how you can deal with this with trustees, it's sometimes about drawing a line and perhaps pushing back slightly. And I think you always need to think of that famous quote from Mrs. Thatcher, advisors advise, but ministers decide. And really that's a motto for charity trustees. Management in a charity advises, but trustees must decide. Now, if you had real concerns that there were governance failings and that your trustees weren't taking their role seriously and that you as management were being left to do everything, then obviously one option is to make a whistleblowing complaint, but that would hopefully be very, very rare. I think from a practical point of view, it's more about senior management from time to time reminding trustees that they have to make certain decisions. And maybe the way that you phrase an agenda, you put on an agenda for a trustees meeting and you flag up for trustees' decision or something like that. And yes, you express a view, but you remind trustees, ultimately at the end of the day, this is your decision. And the same if you're perhaps a bit lower down the chain, you're not in the senior management team, that's something you can put in memos or reports to trustees. You know, these are the various options, but ultimately it is a decision for you as trustees to decide.
Thanks, Tim. Before we move on from that, just one comment from a fundraising perspective. As many of you will be aware, we are great believers in the power of volunteer fundraising leadership. And that very often starts with a board of trustees or within a school or board of governors. It's something that we're very clear in the reports that we write when we do feasibility, is to remind the board of governors that they are ultimately responsible for the welfare of that organisation. And Tim has just confirmed that very well in the last answer. I think it's really important that we as fundraisers recognise that we can do as much as we possibly can to raise money to improve the financial circumstance of the charity, but ultimately it is the trustees who are responsible, and they need to understand and recognise that and play their part, hopefully, in helping to secure fundraising income. If we move on then to question 3, this is one asked of us many times by experienced fundraisers. So I'm an experienced fundraiser and I understand what needs to be in place to fundraise ethically and in line with the law, but I'm unsure of what other policies and procedures the charity needs.
Okay, so obviously the person who's asked the question is quite right. The Charities Protection and Social Investment Act from 2016 introduced requirements for charities to demonstrate commitment to protecting donors and the public, including vulnerable people, from poor fundraising practices, and that led to having particular policies on fundraising. But beyond that, there is a complete myriad of policies that a charity can or should have. And probably the core ones that a charity should have are risk management, investment, safeguarding, conflicts of interest, volunteer management, and complaints handling. And it used to be the case that the Charity Commission would ask you when completing the annual return if you had these policies. The idea being that you had to say, yes, you had them, otherwise you couldn't properly complete your annual return. And so these were always thought to be the core policies. But then there's other areas of law that require you to have policies as well. So you're required to have a health and safety policy, in particular if you've got employees. If you've got more than 5 employees, that has to be a written health and safety policy. We all know that you have to have a huge suite of data protection policies, privacy notices, ICT acceptable use policies, and the like. And if you move into areas like using CCTV or something like that, you need to have a policy. But then you start to move into other areas. And yes, you could have a whole range of employment policies. You could have policies on snow days, all sorts of things, social media policies, policies on returning gifts. And if you don't have a policy on returning gifts, what do you do when you get in that situation when you get a gift that you didn't really want to receive? A reserves policy, and your trustees, again, in their annual report, need to comment on their approach to reserves. An anti-corruption policy, an anti-fraud policy. If you're a grant-making charity, you can have a grant-making policy. You might want to have an editorial policy or a campaigning policy, an equal opportunities policy, or a policy for the use of photographic images of children in fundraising material, and so on. And the list goes on. And you could spend your entire life producing the most enormous lengthy suite of policies. But the reality is that the policies you have should be proportionate to the size of your organization and the activities you carry out. There's no point having a campaigning policy if your charity never engages in campaigning. Same with grants. If you don't make grants, you just make the one-off occasional grant, you don't need a grant-making policy. Your policies should be succinct and digestible. They need to be something that's easy to remember, is easy to understand, and easy to follow. If your policy runs to 15 pages, it may cease to be a policy and be something that is just tucked away in the drawer. Policies should be relevant and tailored to your organization. And what we quite often see is someone on the board is tasked with producing, for example, the investment policy, runs off and does a Google search, finds 3 examples on the website from other people, and just copies those policies word for word. And for example, if you used a policy from a very large charity, it may say that as part of your investment policy, cash is only held in a AAA rated financial institution. Everybody nods wisely because they all think that sounds a really good thing, but don't really know what it means. And then realizes that actually all of your cash is being held in a bank that isn't rated anywhere near AAA, and you've almost immediately broken your policy without realizing it. Now, again, if you have a policy, you need to follow the policy. And as I said before, sometimes it's better actually not to have a policy than to have a policy that you don't follow. You also need to review policies. So policies like your risk policy should probably be at every trustee meeting. Other policies, maybe like conflicts of interest or things like that, you review less regularly, but you should review them because what was sensible 5 years ago may not apply today. So many people who get out their risk policy now, yes, it does talk about viruses, but it doesn't talk about COVID. It talks about computer viruses because they're still stuck in the 1990s and thinking about initial issues with computers. You need to update your policies and make sure they're relevant. Just going on to the next slide, in terms of procedures, there isn't really any set list of procedures that you should have, but there are 2 areas where you would expect to have some kind of procedures. The first one is very much around internal financial controls, being very clear on how funds, particularly cash, will be controlled. And the Charity Commission's got a lot of guidance in that area and also a lot of very helpful checklists. So you can check off your own internal financial controls and make sure that they're okay. In addition, safeguarding procedures. And that again is an area where if you have any involvement with anything that might have a safeguarding risk, you should have safeguarding procedures. And you probably want to look at that across all of your policies. So for example, safer recruitment policies and so on. So quite a lot to think about. I think my starting point would be get the core policies right, make sure you have those, and then look at where else it would be helpful to have a policy. But above all, if you have your policies, make sure you follow them and make sure that they are relevant to your organization.
Thank you, Tim. We're now going to move on to a subject that I know is close to all of our hearts, GDPR and data protection. Again, a question that's been raised by a number of our clients over the last few years is, we lost a large number of supporters from our database when we had a GDPR review, and now we're nervous about contacting those supporters again as we're in fear of breaching the rules. How do we continue to manage our database and not lose all of our contacts?
Okay, well, as I mentioned earlier when we were talking about the question about knowing everything about all aspects of law, I have to be honest, GDPR is not my chosen hot subject. But I think really here we're talking about direct marketing. And the reality is that there is no magic approach. If you don't have a valid legal basis to contact your supporters, you can potentially be in breach of data protection legislation if you send direct marketing to them. But there is a difference between how you contact people. So you don't necessarily need consent to contact people by post, provided you can demonstrate a legitimate reason for doing that. And obviously, if they're on your database, there must be some reason how they got there. Provided you're satisfied that's a legitimate reason, then you can think about post. If you want to contact people by email or telephone, it's more complicated. And that's because of the privacy and electronic communications regulations. And really, you can only do it if you've got people's consent. Now, I know everyone worries that when you try and get people's consent, they don't consent, and then you have to take them off your list. But the reality is, if they're not going to consent, that's not a reason to keep them on your list. Now, one area where this may change slightly is with the Data Protection and Digital Information Bill that's going through Parliament at the moment, which may relax things slightly for charities. Now, this is a good example of something you should be monitoring and watching progress of. So you can sign up to updates from the ICO webpage, and you can also sign up to updates from Parliament, and you can actually get updates about this particular bill. So it's worth thinking about that if this is something that's causing you concern.
Thank you. Moving on to question number 5 then. And again, something I know a lot of internal fundraisers want to know is, where can we signpost trustees to for help with governance, compliance and training?
That's a really good question, and the straightforward answer is on the screen. Anyone who wants to contact me, feel free to do that. But the reality is you can get a lot of information and support for free, and that's something that charities should always bear in mind. Most professional firms like ours that work with charities on a regular basis offer training, information leaflets, email updates, and the like, doing sessions like today and so on. So, for example, we as a firm run a regular free trustee training session, which goes through the basics of CC3. And we tend to find that we get new trustees coming to that. We also have some trustees who come to it every time, even though it's actually the same seminar. We also have regular email updates. We post videos and literature on our website, and it's worth having a look at our website and other professionals' websites. And if you do a Google search, you'll find lots of charity lawyers, charity accountants, other organizations out there who are all trying to help and point you in the right direction. It's also worth looking for umbrella organisations. So, for example, I do a lot of work with almshouse charities, and most of them are members of the Almshouse Association that actually pumps out a lot of information to its members about things that they need to be aware of and which are relevant to them as a type of charity. You also then get organisations like NCVO and Akivo who provide a lot of information. Sometimes you need to be a member, but again, since the pandemic, there's been a lot more information provided free rather than behind a paywall. But sometimes it's worth actually signing up to be a member as well. As I mentioned earlier, the Charity Commission are also looking to think about how they can keep trustees better informed. And I think they're going to start using their trustee charity portal as a way of encouraging and signposting to information. They've done a lot of work in the last few years on trying to make the guidance accessible and understandable. So you might have seen their sort of cartoon 5-minute videos on a whole range of subjects, which are worth watching, because even if you think you know it, you're bound to pick up something that you've forgotten. And at the very least, you should be signed up to regular updates from the Charity Commission, because they put out an awfully good amount of information. Even if they put out a report on an inquiry, it's worth reading because there's lessons to learn and things you can think about. And there's also a lot of guidance on their website, which is in a very accessible form. And thinking back to the question earlier about other areas of law, it's actually surprising how much information is available on gov.uk. So, for example, if you've got an employment issue, you're trying to work out about maternity leave, there is pages of guidance there that's written in quite an accessible way. So it's worth looking into that. There are also from time to time good books that you can get from organisations like Directory for Social Change, and other organisations that produce books written for people who work in charities or charity trustees, which aim to be more of a handbook than a legal textbook. And then finally, if you've got a good relationship with your professional advisors, your accountants, your investment managers, your lawyers, take the chance to actually invite them to a trustee meeting. They love to get out and meet your trustees, but get them along and just say to them, what are the new things coming up that we might need to know about? And I'm sure they'd be happy to take you through and give you a sort of 5-minute update and point you in the right direction.
Thank you. I think, again, very important there that we continue to remind our trustees about the need to remind themselves and to keep themselves up to date with their responsibilities. It's not always it shouldn't be our responsibility to be constantly pushing them, but they need to be reminded, and they need to be reminded fairly. And I think Tim has, in answers a couple of questions, given us some very good advice as to how we can diplomatically make sure that our trustees abide by the law and do what we want them to do. If we move on then, are we right to encourage trustees to invest in good governance and expenditure? Trustees are often reluctant to spend money on anything other than our income objectives.
So straightforward answer, yes, you are right to encourage trustees to invest in good governance and spend money on it. Obviously, always very difficult as a lawyer, because you might say, well, that is what you would say, isn't it? But really, it comes back to the 6 core duties we discussed earlier. And those all stem from principles of good governance. And without good governance, your trustees can risk making mistakes that could be easily avoided. Now, if a mistake is made, provided trustees can show that they acted reasonably and honestly, they can normally escape liability. But failure to comply with good governance is always going to be an issue. And I've mentioned CC3 before. What it says on this subject is, where there is concern about a specific issue, the trustees may wish to consider taking independent advice from a suitably qualified person. Now, it's always difficult, as charities want to make sure that every penny you have is spent furthering the objects of the charity. And that does mean that sometimes you might question whether it's appropriate to spend money on professional fees. But sometimes it's actually going to be a requirement. So, for example, charity disposing of property needs a qualified surveyor's report. You're probably going to have to pay the surveyor to do that. It's also the case that quite often a lot of professionals out there may offer charities pro bono advice. For example, a lot of law firms offer pro bono legal advice for charities, but you do have to be slightly careful about this, because it really depends about the area of law you're looking for advice on. So if, for example, you're looking for some advice about employee rights to do with maternity, then probably there's nothing specific from a charity law point of view that impacts on that advice. And it may be appropriate to get that advice pro bono if you can. But if, for example, you were looking at disposing of a property that's permanent endowment, then actually going and getting free advice from a residential conveyancing solicitor who's never dealt with a charity before may actually be a bad thing and may lead to you making quite a significant mistake. So you have to judge when it's right to take on board expert advice. And it's important to get it right and use your funds sensibly and proportionately. Now, what you may have seen last week, if you're signed up to the Charity Commission website updates, is that the Charity Commission last week issued an official warning to Christ Church, Oxford. Now, the college has been involved in a very long, difficult dispute involving the former dean who left the college earlier this year following a mediation. But back in 2019, the Commission had given advice to the trustees that they should engage in mediation, and as part of that advice, required the trustees to have a close oversight of costs. Now, back in December, the Commission asked the charity how things were going on the subject of costs, and according to the report, the trustees couldn't provide any real information. They weren't sure what they'd spent, they didn't have a fixed budget, and they appeared to be making decisions about costs retrospectively. When you then read on in the report, you discover that over 4 years, the charity spent £6.6 million on legal and public relations fees in relation to the various disputes, of which 5.3 million was approved retrospectively. And the Commission's concern and the reason for the official warning wasn't because professional advice had been taken, and wasn't actually because of the level of the fees, but was because they felt that the trustees hadn't managed those charities' resources properly or really understood what they were doing in relation to costs. So the lessons to learn in particular from that warning are, yes, it's appropriate to use professionals in the right circumstances, but make sure that your trustees have thought about and approved the costs at the beginning. Be transparent with everyone about the costs that are being incurred and how the charity is going to fund them. Where possible, try and agree and stick to a budget. And above all, make sure that what you are spending is proportionate to the issue in dispute. Obviously, £6.6 million sounds like a very large figure for costs, but it may be that it was proportionate in the context of the dispute. That's really for other people to think about. But that's the key thing. Always make sure you know what you're going to spend as best you can, and that it's proportionate to what you actually want to do.
Thank you. Our next question is one that we hope few of our clients ever have to answer, but nevertheless, it is an important fact to understand. So we ran a campaign that did not reach its target, and so the project will not go ahead. What should we do about the money that we've already received? Very important, I think, that all of our clients, everybody out there, understands what the options are available to you should a fundraising campaign not work in the way that you'd hoped.
Right, well, this is quite a complicated area. And if you're raising funds for a particular project and the appeal fails to reach its target, then you have a failed appeal. And what happens next depends upon how the literature and the material for the appeal was worded. Now, if you're following the fundraising code, then in there's a particular paragraph in 2.75 that says if you're fundraising for a particular purpose, you must include a statement saying what will happen to funds you receive if the total amount raised is not enough to reach or is more than the target. And the Charity Commission guidance has exactly the same information in their guidance on fundraising. And they have the whole example about raising funds for a scanner in a hospital and saying something along the lines of, if you fail to raise enough funds, then the funds raised will be used for the general purposes of the charity. Now, quite often, surprisingly, people fail to do that. And sometimes I think it's because people think, well, there's no risk at all that we won't raise the money, or we don't want to highlight that we're worried that we might raise the money, or we just haven't thought about it. And the difficulty then becomes that if you've raised funds for a specific purpose and the purpose has failed, legally, you are treated as holding those funds on a resulting trust, not for your charity, but for the people who donated the funds. And it all then becomes about how do you return the funds. Now, up until recently, at this point, you would have turned to the very archaic rules set out in the Charities Failed Appeals Regulations 2008, which were delightful because they still worked on the basis of people advertising on notice boards. They thought that there was still such a thing as local newspapers, and they actually thought that people used posts to communicate with donors, and therefore made it very complicated as to how you dealt with a failed appeal. As of the 31st of October 2022, those regulations have now been revoked, and sections 63A and 67A of the Charities Act 2011 have been inserted by the Charities Act 2022 and have come into force. Now, they changed the position ever so slightly. It's still the case that if an appeal fails, then the starting point is those funds are held on a resulting trust for the people who donated the funds. But as before, it's accepted that in some circumstances, those funds can be applied for other charitable purposes, what's known as CPRE. Now, as before, the court and the commission can direct that funds go CPRE, either if it would be unreasonable to have to go through the process of returning them because it would cost more to return them than to keep them, or if because of the way the gifts were made, it would be unreasonable to expect for them to be returned. However, of more relevance to charities is how charities can now deal with this themselves. So there are certain circumstances in which the funds that you've collected can be applied CPRE if you meet one of the following conditions. And the first one is if the sum donated was a single gift of £120 or less, and during the financial year, it's reasonably believed that the amount given by that particular donor for that particular purpose is £120 or less, and also that the donor didn't say the funds would have to be returned if the purpose is failed. Secondly, is if the donor can't be identified or found, and you've carried out actions that have been agreed between the commission and the charity to find such donors. Now, in the past, this was where you had to go through the process of adverts, sending out letters, and the regulations were quite specific on sending out notices by post, asking individuals to sign a formal disclaimer saying that they didn't want to have the money back. And in more recent cases where we've dealt with failed appeals, we've had people who've only ever dealt with donors by email and have struggled, then realizing that they then have to write to hundreds of donors to say, can you have your money back? And these new rules mean you don't have to do that. So you can engage with the commission and say, right, we did this campaign by social media. We dealt with everyone by email. We've got everyone's email addresses. Is it okay if we email everyone and say, if we don't hear back from you within X period of time, we'll assume you don't want your money back? And the third category is, as before, money that goes into a collection box as cash, or where you get funds and you can't distinguish them from other funds, or if it's money raised through a lottery or a competition or something like that. Now, if you meet one of these conditions and therefore the property is available to be applied CPRE, it used to be the case that you then would have had to get a scheme from the commission, but you don't need to do that. Your trustees can pass a resolution and say, this money is available to be used CPRE, we'll use it for these other purposes which are very similar to the purposes for which we were fundraising. Now, if the amount of money involved is over £1,000, that resolution goes to the Charity Commission, and you have to wait for the Charity Commission to concur, and assuming they concur, you can then use the money for those other purposes. Where again that differs to the previous regime is that under the previous regime, once the Commission had made a scheme, donors still had 6 months to come forward to ask for their money back, which always made it slightly awkward because you could think, we've got this pot of money, we can now use it. Oh, we've actually got to keep some of it now for 6 months. That's gone as well. So once the Commission has concurred with the resolution, there is no requirement to hold the money any further. You can use it for your purposes. So main changes really, you do need to be keeping track of individual donors if you can, to see if they go over that £120 threshold. If your campaign fails, make sure you engage with the Commission and discuss with them how you're going to actually liaise with donors to think about returning money or asking them if they want money back. And then once you've done that, think about your resolution. But I think that the real takeaway point is you shouldn't need to know any of that at all. You should never need to engage with these regulations or these rules. Simply word your appeal correctly in the first place. Just add those words at the end to simply say, if we fail to raise enough money, the money raised will be used for the general purposes of the charity. And then you'll never get into this situation, and you'll never find yourself spending hard-won charity money trying to sort out a mess of returning funds because you left out some small print on the bottom of a document.
Tim, thank you. And then our final question, again, one that is posed to us very often. I'm sure other consultants find themselves having to answer the same question, and a lot of our clients may consider this as an option. But we are thinking about employing a fundraising consultant to raise money on our behalf. Can we pay commission on funds raised?
Okay, so I think everyone will probably know if you're working with a third party who's going to raise funds on your behalf, then they would be a professional fundraiser, and you're back under the Charities Act 1992 provisions. And in particular, you need to make sure you've got a proper written agreement in place that deals with those requirements under the legislation before any fundraising is carried out. And that's an agreement between the charity and the professional fundraiser. And one of the elements of that agreement is going to be explaining how the professional fundraiser is going to be paid, and also detailing the solicitation statement that you would expect to be made by the professional fundraiser. Now, it's very difficult because there is guidance about solicitation statements from the Cabinet Office that came out in 2008, and it doesn't really deal with the situation where you're getting paid commission. It does set out lots of examples, but there isn't a clear one for commission. Now, I think the correct legal answer is that yes, you could pay a professional fundraiser on a commission basis, and your statement is probably going to be something along the lines of, I'm fundraising for the benefit of X charity. I'll be paid 10p of every pound raised by the charity from every donor that I recruit during the course of this campaign. It's estimated that I'll be paid X in total for the work on the campaign. Now, in reality, if I think you're going down a commission route, you're probably actually going to be being asked about a much more complicated commission type arrangement, because really the 10p in the pound arrangement is actually almost akin really to a fixed fee. So you would have to have a very detailed explanation as to how the commission was worked out, and your solicitation statement would be getting very long. I think in most cases, it probably would not be appropriate to go down the commission route, because it potentially encourages the wrong type of behaviour. And it also can be quite difficult to explain to people who are being approached for funds. I think it is better if a fundraiser is perhaps paid on a fixed basis, because it then incentivizes them to do the job that they're paid to do and doesn't lead to them going perhaps in the wrong direction. But if you did go the commission basis, I think you'd want to definitely make sure it's in the charity's best interests and that you couldn't perhaps get an alternative arrangement. Certainly be clear that the level of commission is proportionate to the amounts raised. So, for example, you wouldn't want to say, we'll pay you commission of 90% on the first 100,000 and 1% on everything over that, if you're only expecting to raise sort of 200,000 or something like that. And above all, try and make sure that the commission approach doesn't encourage any behaviour that is inconsistent with your policies on fundraising. And that's going to require you probably to monitor much more closely what the professional fundraisers are doing.
Thank you, Tim. Very quickly on that one, from a gifted perspective, we obviously never work on a commission basis. And there are a number of reasons for that. But one is particularly when you're working around major gift capital campaigns and the structure set up engages volunteers, it engages supporters coming from different directions who may have very different relationships with different people involved in the fundraising. So if you have a commission-based agreement, the chances are that the person you've got that agreement with will want it to apply to all money raised. And it could be your biggest gift has been raised by somebody or has come from somebody who the fundraiser has had no direct contact with. It's come through the headmaster or, the chair of governors, a chair of trustees, or just a senior fundraising leader, a campaign chairman. It can be very, very messy. And just going to a potential major donor prospect and saying, we are going to get 10% of your £50,000 or your £250,000 or your £500,000 could very well put that potential donor off making any gift at all. So we avoid it, as do most, I think pretty much all reputable fundraising consultancies. Right, I'm going to stop sharing the screen in a second, but let's see what questions we may have. I have one here, Tim. CPRE. Can you just explain what CPRE is, please?
Yes, and I love the fact that the person who asked the question is good at French as I am, because I built it the same way. So yes, apologies. So when I was talking about failed appeals, I talked about CPRE. So essentially what that means is when you do your fundraising appeal, you're raising money for a particular charitable purpose. So let's say we're raising money to build a refuge for homeless people. We fail to raise enough money. We're then left with a pot of money that was meant to be used for building a refuge. And we're able to go to the court or the commission or follow the processes that I talked about, because we can say what's known as a CPRE occasion has arisen. Now, that's dealt with in Section 62 of the Charities Act. It essentially means a circumstance has arisen where the money can't be used for the particular purposes for which it was raised. And we look at, is there another purpose close to that purpose which it can be applied for? and that's what's known as a CPRE. So a CPRE occasion arises in circumstances where you are looking to use money for similar purposes, but you need a commission scheme to do it. And the issue always is that when you're dealing with trusts, you can't just say, well, we got this money for reason A. Well, actually, we're a charity. The other things we do are just as good. We'll use it for reason B. You need to have an actual occasion arise that enables you to say, we can use this money for these other purposes. And that's known as a CPRE occasion.
Thank you, Tim. Are there any other questions? If so, please either raise a hand. Well, it's hard to raise hands, but you can certainly type a question in. I'll give you a couple of minutes to think if you've got any more. I hope that Tim has answered any questions or any queries, or the questions we've created cover something that you have a particular interest in. A copy of this webinar will be available on our website. If you haven't been able to take it all in, I'd urge you in the next few days, if you want to go and have a look at it again, make any notes you want to make. Obviously, there's been a wealth of information passed on to us by Tim, for which we're incredibly grateful. And hopefully people have made good notes. But if not, do please get back in touch with us. We do have a copy of Tim's notes. We can pass on certain things. And of course, you know, if you feel you need advice, who better to go to than Tim and Stone King? He is absolutely an expert. He's helped us and our clients over the years, which is why he's here today, because we absolutely trusted his knowledge and expertise. So if there are any more questions, please say so now. If not, we're 10 minutes ahead of schedule, but I would thank everybody for your attendance. I hope you found it interesting. We've had more than, well, we've got 53 guests today, which is fantastic. Wonderful numbers. And it just shows how important good governance is to all charitable organizations. But I wish you well. I wish you luck with your fundraising, and I wish you luck with your governance challenges. And it's been very good to see you and very good to have you with us. All the best. Take care now.